Hi, I'm Karl Konrad and welcome to our weekly edition of Australian Immigration News. This channel is brought to you by Australian Immigration Law Services, the company I founded right here in the heart of Sydney more than 26 years ago now. Today we're busting 5 major myths about the 491 visa. I've mentioned some of them in various videos, but it's time to put them all together. So let's get started. I can't work remotely in a regional area for a company based in Sydney. Remote working has been common long before COVID, since the introduction of the 487 regional visa in 2007, replaced by the 489 visa in 2013, and the 491 visa came in 2019, remote work has always been accepted. So in the last 18 years of my 26-year career in dealing with regional temporary visas and then going on to help people gain their PR, I've seen hundreds of clients enjoy working remotely, staying in Australia and still qualify for their PR visa later. And you can work remotely for any employer even if they're based outside of Australia. It's all about where you are physically located when working here, not where your employer is based. Immigration even stated it's okay to attend a non-regional city office once a month for training. Myth number 2, leaving to live in other regional areas will risk my visa status and chances for citizenship. Not true. For the last 18 years of provisional regional visas, moving from one regional area to another is fine. Your visa conditions explicitly state you must live in a regional area, but it does not specify you must stay in the area that sponsored you. Your 491 grant letter even has a link to a postcode range to help you choose your regional locations. Many sponsoring states and territories threaten visa holders, saying they'll report them to DOHA if they leave. But in reality, these threats are just scare tactics, for DOHA is not interested if you leave your regional area. With regard to citizenship, risking it by moving is entirely false. Migration Tasmania once claimed that leaving your sponsoring state could affect your character assessment for citizenship, but that is simply not true. Your citizen application focuses on character by examining if there are any criminal histories. Civil agreements with your sponsoring state does not carry criminal penalties if broken. In fact, these agreements have no penalty clauses in them at all. Moving regions does not impact your eligibility for citizenship. Myth number 3, you must live in regional Australia for 3 years to qualify for PR. Nope, that's false. There's no mandatory residency requirement for PR using the 191 visa in the regional stream. There is a residency requirement in the Hong Kong stream, but not in the regional stream. Condition 8579 limits your activity while you're in Australia, but extended time outside of Australia does not breach it. And the 191 visa legislation itself does not specify any residency requirement in the provisional regional stream. So you can spend as much time outside of Australia as you like after your initial visa grant. Myth number 4, when I come to Australia, I have to work in the occupation I was sponsored for. Not at all. On the 491 visa, you can work in any occupation you like, or start your own business, or if you have enough money, just sit on the beach and watch the world go by. With some sponsoring states like the Northern Territory, they try and bluff you. You must work and stay in their state in the occupation they sponsored you for. On their website, they state, accepting a nomination from Australia's Northern Territory government means that you are agreeing to the following conditions. Live and work in the NT in your skilled occupation or closely related skilled occupation for at least 3 years from the visa grant. That is, of course, complete nonsense. A sponsoring state or territory does not have the right to dictate to you which occupations you must work in. There is no work limitations on your 491 visa, and certainly none that try and force you to work in any particular occupation. Myth number 5, if I break up with my partner and I was the secondary applicant, I can't apply for the 191 PR visa. Completely inaccurate. Many couples split up during their 3-year wait to apply for PR. However, both can apply individually for their PR once they meet the basic criteria, holding the 491 visa for 3 years, having 3 tax assessment notices, complying with condition 8579, and substantial compliance with the other visa conditions. When a relationship ends, the secondary applicant should create their own IMI account so they can update the department on any changes as required. Importantly, there's no legal requirement to inform the department of a breakup or new relationships. Many clients have separated and still successfully lodged and obtained their permanent residency. This week's policy tip is triggered from a question in our comments section. My policy tip question. You've mentioned before that the federal government and most states have a different policy for counting skilled work years versus skill assessment bodies like ACS. With ACS, for example, you automatically get 2 or more years deducted from your skilled work starting date, but you've suggested that it is still possible to claim those years when applying for a skilled visa. The question goes on, but essentially it relates to the issue of deeming dates, where some skill assessment bodies take off work experience time from your points calculation. There is definitely a policy about this issue in the DOHA Procedural Advice Manual relating to Schedule 6D, which regulates the points test. While the policy does say case officers are meant to have regard to the skill assessment body's deeming date, they are also meant to act in the following manner. The policy document states, if the skill assessing authority's opinion would result in the applicant being awarded less points than the applicant claimed in their EOI, then decision makers should consider the information in ANSCO and apply the more beneficial outcome in determining when the applicant was working at the skilled level. We have not had any issues claiming the extra points except for New South Wales nomination applications, which, despite their assurances, still do not follow DOHA policy. If anyone would like to discuss this issue in detail, please book a time. As always, we are here to help if you need it. You can book a time online by visiting our website at australianvisa.com, or if you're in a hurry, we can squeeze you in earlier if you just pick up the phone and give us a call. Please don't forget to support the work we do here at the channel by hitting that like icon and subscribing if you haven't already done so. As always, take care out there and I'll see you next time. So bye for now.